The New South Wales Reportable Conduct Scheme requires the heads of relevant entities to notify the children's guardian of reportable allegations and reportable convictions against their employees. This is because the purpose of the Reportable Conduct Scheme is to protect children from harm. This requirement is detailed in Part 4 of the Children's Guardian Act 2019. Throughout this video, we'll just refer to this as the Act. This video is to inform employees about what is required of the relevant entity when their employee is the subject of a reportable allegation or conviction, and what an employee can generally expect in the process of a reportable conduct investigation. If you're new to the Reportable Conduct Scheme and need some more information about the definitions of reportable allegations and convictions, relevant entities and employees, please start by watching our video, Introduction to the Reportable Conduct Scheme. If you're an employee of a relevant entity and someone makes a report about you, and that report meets the definition of a reportable allegation, the head of your organisation must take action. In addition to obligations under our Act, depending on the seriousness and type of information reported, your organisation might be required to make a report to police or to the Child Protection Helpline. Under our Act, the head of your organisation must tell us about the reportable allegation or reportable conviction within 7 business days of becoming aware. And unless we decide there are reasons not to, they must assess and manage risks, which include any risks to you, conduct an investigation, make findings for all reportable allegations or determinations for all reportable convictions, and provide a report to us about the findings and the action they have taken. When making a finding, the head of your organisation must give consideration to factors set out in Section 40, subsection 3 of the Act, including whether the reportable allegation includes conduct that's in breach of professional standards, codes of conduct, or accepted community standards. This is one of the many reasons it's so important for you to know what the organisation's code of conduct says and what the other expectations there are on you in your professional or volunteer role. Employees are often really concerned that they won't have the opportunity to respond to the allegations against them, or decisions will be made without considering the evidence they have to bring. The Act requires the head of your organisation to have regard to what are called the principles of procedural fairness when they're handling or responding to a reportable allegation or reportable conviction. In short, it means that the process will be fair, including that you will have the chance for your information to be heard, the decision maker will treat all parties equally, and you will be given the reasons for the decisions that are made about you. Part of our role in oversighting an organisation's investigation is to ensure that employees are being afforded procedural fairness. It's important to know that a procedurally fair investigation will usually involve certain steps, but when and how these steps are followed can be different in every case. This is because every investigation is different and reflects the individual circumstances of a matter, which could include a requirement by police, the Department of Communities and Justice, or our office that your organisation suspend or defer the investigation. Being responsive to the safety, welfare and well-being of children impacted by the investigation, or considering the rights of other parties involved in the investigation. Once you've been informed at an appropriate time that there has been a report of reportable allegations or a reportable conviction against you, there are some things you can generally expect. This includes being kept informed of the progress of the investigation or determination, including in circumstances where there has been no progress for a period of time, and being given the opportunity to respond to the reportable allegations against you, whether in person or writing. Procedural fairness also involves giving you the reasons for any proposed adverse findings or action and giving you the opportunity to respond before the matter is finalised. And finally, we expect entities to give you information about what you can do if you believe there was a lack of fairness in the investigation or outcome. If you're concerned about the way an allegation against you has been handled by your organisation, then you should raise your concerns with the head of your organisation as soon as possible. It's best to do this in writing if you can. If you're not satisfied with how the head of your organisation responds to any concerns you raise with them about their handling of reportable allegations or convictions, you can make a complaint to our office. There is a form available on our website for this purpose, where you can also find more information about the Reportable Conduct Scheme and reportable conduct investigations. Working with children is a great privilege and a great responsibility. Everyone has a role to play in keeping children safe.